day of hearing bills, and with us this morning is Senator Pappas to present Senate File 152. Call the roll, please, Debbie.
Representative Craigo.
Here.
Representative Chestick.
Here.
Representative Harrelson.
Here.
Representative Jennings. Representative Nemec.
Here.
Representative Oakley. Representative Provenza.
Here.
Representative Rodriguez Williams.
Here.
And Chairman Washut.
Here. All right. Senator, please walk us through the bill.
Thank you, Mr. Chairman. Just. This one's on too. Okay, is that much better? I'll get it closer so that you can hear me. Just a little bit of background. Last year, we passed a bill, occupational therapy compact bill. And there was a problem that the state board ran into dealing with background checks. And all this is more of a technical correction to the bill last year. And so it's fairly simple. What happens is that under the practice of occupational therapy and occupational therapy assistance, to obtain a license in Wyoming does not require a background check. But in order to practice under the compact in other states, the background check is required. So as they were applying for background checks from the FBI had an issue with our statute. And there are 6 basically requirements that the FBI wants to see in order to release a background check. And so the DCI, our Wyoming Division of Criminal Investigation, was not able to get those from the FBI. And it come to find out the reason, there's 6 reasons, and one of the reasons is it must identify the specific category of applicants, licensees falling within the purview, thereby avoiding overbreadth. That's directly from the FBI. So if you look on page 2 of the bill, this is the existing language in 719-201 in Romanet, I guess that would be 33, right? Says all persons applying for a compact privilege under this Occupational Therapy Act as provided in those statutes. Persons was not, it was not sufficiently specific for the FBI. So all we're doing here is actually changing the word persons and inserting currently licensed occupational therapists and occupational therapist assistants. We believe with being specific to the profession that the FBI will now allow the release of the background check. And so we're hopeful that this will pass this session so we don't have to go another year for the state board to be able to allow these professionals to work under a compact. So it's pretty simple. I stand for questions.
Questions for the senator? We've had a couple of these types of bills this year, and it seems like maybe an FBI audit revealed some deficiencies in various places for record checks. So,
Yeah, frankly, Mr. Chairman, there is this, we're not the only state that's run into this. And so Congress is looking, the House is got a bill to force the FBI to do this, but who knows when that will pass. And so our state board needs to be able to allow these folks to do it this year. So,
Representative Craigo.
Thank you, Mr. Chairman. Just a question, Senator. So I'm just having trouble with the word currently. And maybe I'm just not thinking straight. Second to last Friday of the session, but I mean, we're taking out the word persons applying for, but when we're inserting the word people currently, people that are already licensed, I mean, are we narrowing down to, we have 2 categories of people. Do we want to keep the other category of people within the statute or not? Is that, are we trying to exclude that set, the category of people who aren't currently licensed but are applying? Does that make sense, Senator?
Senator,
Mr. Chairman, the reason currently is in there is because not every licensed OT or occupational therapy assistant is required to have a background check. Only those applying for the compact. But the only people that can apply for the compact are currently licensed OTs.
further questions? Seeing none, do you have any witnesses to testify on behalf of your bill today?
Certainly, I believe the board is here. They could speak, I would imagine.
Good morning. State your name for the record and tell us what you want us to hear.
Good morning, Mr. Chairman, members of the committee. I'm Joanne Reed. I'm the administrator for the A&I professional licensing boards, of which the Occupational Therapy Board is one of the 20 that we serve. The good senator summarized it perfectly. There's nothing I have to add unless anybody has any specific questions for me.
Any questions? Thank you for getting up early and joining us this morning. Anyone else in the room wishing to testify on 152? Seeing none, we'll close public comment. Committee, what's your preference? Moved by Representative Oakley, second by Representative Chestick. Discussion? Amendments? Question being called. Debbie, you want to call the roll on Senate File 152?
Representative Grego,
Aye.
Representative Chestick,
Aye.
Representative Haroldson, Representative Jennings, Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
Aye.
and Chairman Washut.
Aye.
We have a total of 8 ayes and 1 no.
With that, Senate File 152 is passed judiciary.
Mr. Chairman, if you notice, I don't have a person on this thing came very at the last minute by the state board. So the bill was filed very late and I don't have any folks on the House to carry it. I would ask if someone on the committee would like. If not, I'll go find someone.
Anybody wishing to carry the bill? If not,
Yeah.
yeah,
We'll sort it out.
yeah.
One of us.
We'll team tackle it or something.
Okay, and so I can give you my notes if you'd like. Okay,
That'd be great.
All right.
Thank you.
Thank you.
Welcome, Senator.
Good morning, House Judiciary. Good morning, Mr. Chairman. Thanks for flexibility with the schedule this morning. Good senator or good representatives. You can tell I just do that by habit. I'm getting ready to prepare a bill. Representatives, you have Senate File 167, Domestic Violence Protection Order Hearings, Remote Appearance. What this bill does is it allows for a person who is a participant in a protection order or stalking order or sexual assault hearing to ask the court to appear remotely and kind of allow that process to be part of the initiation of the proceedings. So the court is aware of this request without need of getting counsel or a special motion to appear remotely by the court. It just becomes part of the common practice associated with the initiation of these proceedings. It's at completely the court's discretion, so the court can easily deny the request, allow both parties to appear remotely, or allow one party to appear remotely. The reason behind the bill may be obvious to many of you, which is really to avoid the physical interaction of two individuals who are clearly not to be around each other for whatever reason. And so with technology, all of the courts are now, because of COVID, completely capable to be able to allow for this type of option. And so it's not burdensome on the courts, but maybe not part of our customary practice, particularly in these types of hearings. And so that's the purpose of the bill. I'm happy to answer questions. There's many of other good reasons for it, but it's Friday morning and hopefully you can appreciate the purpose and intent of the bill.
Question for the senator. Representative Provenza.
Thank you, Mr. Chairman. Just want to ask your opinion on this. I don't think it'll become an issue, but jails potentially maybe not wanting to take those in custody over to the courthouse and wanting to do video probably won't be held by the court, right? Like they'll still want the accused person to be
Senator.
there.
Mr. Chairman, so a civil protection order or sexual assault hearing is a civil proceeding. And so there's no criminal sanctions associated with it. It is common, however, for a respondent of one of these actions to be in custody, usually for an underlying crime, usually domestic violence of some sort. And the courts most often, more often than not, have those defendants, even in a criminal case, appear remotely for their initial appearance. So that's common practice and has been common practice for decades now, I would say at least a decade, if not longer. So that is not unusual, and the courts interpreting remote appearances by criminal defendants has found that to be lawful and constitutional.
Further questions from Senator? Thank you. Do you have any witnesses, today?
I
Anyone
know that there's folks who want to testify, but I don't have anyone with me. It may be important for you to know that I was asked to bring the bill by members of my local safe house. So that's the, emphasis for the bill.
Representative Jennings.
Thank you, Mr. Chairman. Senator Nethercott. So having not practiced law, but watched a little bit of Perry Mason. So is there an option in this where, say, the petitioner says, no, I want the other person there?
Senator.
Mr. Chairman, certainly that person can communicate that to the court, and the court can determine that. I do think it's important to recognize it's completely in the court's discretion. And so typically these petitions have, they're required to have the details of the underlying basis for the reason for the request. And the court can evaluate most likely the seriousness of the allegations and then make a determination on the appropriateness of that. Oftentimes when it may not be as serious, but people can sometimes abuse these processes, which I have seen as well. The court may demand both parties appear and have a good conversation with both of them and require them to come to the court. And I do think the court would prefer people obviously to be live, but there is a good sense, even from a respondent's perspective, to not be introduced to scenarios where they may be accused of negative interactions with the petitioner. And it just avoids that entire scenario altogether, particularly if they are actually charged with an underlying crime. It's a very serious crime at stake. There's a lot at concern for them, and the protection order hearing is quite frankly less of a concern to their liberty for a criminal conviction. And so counsel will frequently advise that defendant or respondent to just avoid that whole thing altogether, because it's not worth an additional charge or an additional allegation of an accusation of he looked at me or he said something under his breath and those types of circumstances. So there is a way to avoid additional conflict between two individuals who, again, likely should not be having any contact with each other.
Thank you, Senator. Anybody else in the room wishing to testify? Mr. Winnie?
Mr. Chairman, Bill Winnie, Sublette County. From the perspective of these proceedings going in front of the jury, I would remark during my active duty career in the Navy, I served as a court-martial member twice on serious and sensitive charges. Such things as show cause boards, where you would be hearing testimony and things like that. And then, of course, I was a Article 15 hearing officer for some 5.5 years, hearing some 600 or 700 cases. And from my perspective, for someone on a jury or something like that, this would not be an issue. As long as there's the interplay where questions can go back and forth, I would perceive that a jury would find this not a problem. Subject to your questions, thank you.
Thank you, Mr. Winnie. Anyone else in the room wishing to testify? Ms. Muir, state your name for the record and tell us what you want us to hear.
Good morning, Chairman, committee members. Just very briefly, I'm Tara Muir, Public Policy Director with the Wyoming Coalition Against Domestic Violence and Sexual Assault. We're the organization that has member programs. One of them is the Safe House in Cheyenne. We have advocates across the state, hopefully one per county or half of one. But they all expressed great support for this for various reasons, but mostly not every protection order gets an attorney to help argue it. Advocates need the assistance that this bill provides to help a petitioner not have to make such a strong argument that there's serious safety concerns in a case. There is a practicing attorney who's done a lot of protection orders that is on Zoom to answer any of your practicing kinds of questions, but fully supported.
Ms. Muir, I'm not sure I followed your comment there. This changes the burden on the petitioner in some way?
It assists petitioners by having it clearly in the law that a judge can do this. An advocate, when they're helping fill out the paperwork, can help explain that there is an option like this if the petitioner needs it, and then the petitioner can ask for it.
Further questions from Ms. Muir? Being done, thank you for coming out this morning. Anyone else in the room for Senate File 167? Seeing none, want to bring us home? Any further comments, Senator? No. Oh, one more on Zoom. I'm sorry. Ms. Core online, please bring her in here. Thank you.
Thank you. Good morning, Mr. Chairman and members of the committee. Thank you for allowing me to testify in support of this bill. My name is Jeannie Core, and I am recently in private practice, but prior to that, I was a program attorney for the Wyoming Coalition Against Domestic Violence and Sexual Assault. And in that role, I have represented petitioners throughout our state in protection order hearings for a number of years. There's three main reasons that this bill is important. The first is that courts are required to have subject matter jurisdiction to hear a case. What that means is they have to be the court in the place where it happened. Frequently after these crimes, people flee. A sexual assault survivor leaves campus and goes back to her parents. Mom of young children, goes to her sister's house out of state. If you are required to appear in person, then you're required to return back to essentially the scene of the crime. This can create real logistical challenges, financial concerns, childcare issues, and when we require people to return back to the county where their protection order was filed. Another reason that this bill is important is because of the impact of trauma. These hearings are some of the most personal and private things that happen to people. It's talking about intimate details of their romantic relationship or a dating relationship. And these are really, really difficult and personal things that are being brought to the court. This trauma is super impactful for petitioners, and it can make a huge difference the setting in which they have to testify to these crimes. For example, I represented a 15-year-old stalking victim who was able to testify from her living room sitting next to her mom. And that support made all the difference for her in her ability to tell her story. I represented a person who was a sexual assault survivor and was able to testify from the offices of the domestic violence program in her county. So this impact of trauma really makes a difference on people's ability to follow through with a protection order. And the last and most important reason is the impact on safety. When a person files a protection order, that's the most dangerous time of their relationship. It's the most likely time for someone to be harmed or to be murdered. And so we tell people, please come to the court. We're going to give your perpetrator advance notice of where you're going to be and when. And with all kinds of details about what you're alleging that is going to make that person pretty angry. And this has created dangerous situations a number of times. There are many reported incidents of people being murdered in, outside the courthouse or on their way home. Even in my personal experience, I've had a time when a perpetrator was waiting by someone's car after we left the hearing. Another time when, as we're walking out of the courtroom, a threat was made under the perpetrator's breath, which fortunately an astute bailiff heard, and the person was able to be charged. So we cannot underestimate the impact of safety that is needed in many of these cases. One of the great things about COVID, if there were great things about COVID, is that it taught us that remote appearance isn't the end of the world. We got really good at it. And there are many courts that are still allowing it regularly, but there are others that have kind of gone back to not wanting to. And, remote appearance isn't perfect, but it can be so much better and so much safer for people who are survivors. And so I appreciate being able to talk about this, and I'm happy to answer any questions.
Thank you for being here this morning, Ms. Gore. Very useful testimony. Any questions? Seeing none. Thank you so much for joining in.
Thank you.
Anyone else wishing to testify? With that, we will close public comment. Committee, what's your preference? Moved by Representative Craigo, second by Representative Provenza. Discussion. Representative Oakley.
Thank you, Mr. Chairman. Just a couple things. And I think this was answered, but what this does is authorize, may petition. So therefore, it's in writing, and of course, a respondent or defendant, whichever, maybe both, has the opportunity to weigh in on it. So it doesn't take away any of that. And then also, of course, these don't go in front of a jury. They wouldn't, and we would never have somebody appear remotely if there was a jury. So just to keep this in the limited scope that it applies to, and they have the right to talk, to respond to, maybe they would oppose it, and then the judge could decide, but it doesn't take away their voice.
Committee, any further comments, discussion, amendments? Question being called. Senate File 167. Debbie, please call the roll.
Representative Craigo,
Aye.
Representative Chestick,
Aye.
Representative Harrelson, Representative Jennings, Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams.
Aye.
And Chairman Waschuk.
Aye.
9 ayes and 0 noes.
Very good.
Mr. Chairman, in the event a miracle occurs and this bill is able to make committee of the whole, Representative Jennings is a co-sponsor, and I think he'll carry it on the floor. You go ahead. Thank you.
Terrific. Thank you. Representative Jennings will put you down. All right. Thank you. That concludes our work for today. On Monday morning, the committee will meet to discuss interim topic.
Yeah. I'm not crazy about it.
Debbie? Debbie?